Welcome to Cornell Cooperative Extension and our monthly Consumer Issues program. I'm Carol Fisher, Consumer Educator here at Cornell Cooperative Extension of Tompkins County. As we finally head into spring and summer, we also head into the home improvement season. While there are many honest and reputable contractors here in our area, there also may be some who are trying to separate you from your money without doing the work as promised. Today, we are very pleased to have with us New York State Assistant Attorney General Mike Danaher, who will discuss with us issues that will help us become wise consumers in the home improvement market. Issues such as how to recognize and avoid home improvement scams, how to choose a home improvement contractor, what to do if we, despite our best efforts, find ourselves in a difficult situation. So, without any further delay, Mike, welcome.
Thank you, Carol. Good morning, everyone. I'm glad that you're all here with us today. As the buds are starting to pop on the trees, so will the home improvement contractors start to come out from their winter's hibernation. And we all know that our largest expense that we have in our lives is probably our home. There's not too many that buy things that are much more expensive than what homes are nowadays. And so we have a really vested interest in keeping those properties up to maintain their value and to provide us with a comfortable place to live. A lot of people don't realize that when they go to get a home improvement contract, that there are certain rules and requirements that are associated with it. And it is incumbent upon those who do home improvement contracts to make sure that they follow the law. As we've always talked about here, the consumer laws are not designed to give consumers an advantage. They are, however, designed to protect them and to hopefully create a more level playing field so that they can make good decisions. In the typical case, the home improvement contractor knows what needs to be done, knows the procedures and the materials and all the things that need to be done to fix something or to upgrade something. But we as consumers don't know what is entailed. We don't know what boards and how much weight has to be distributed over a certain header or that sort of thing. So we don't know that, and we rely on the home improvement contractor, and as a result, the law exists to help protect consumers in going through one of those transactions. People don't realize this, but every home improvement contract must be in writing. So the contractor must provide the homeowner with a written contract for any home improvement. And home improvement is defined under the statute, but they're required to. I know there's lots of times that people say, oh yeah, I can do that, and I can do this, and you can pay me when I'm done, or whatever, and they get nothing in writing. They don't know what it's actually going to be, and that can always lead to problems. But home improvement is actually an all-encompassing type of definition. It doesn't include just coming to your house and putting a new roof on, or putting a porch on, or doing something directly with the structure itself. It can include driveways, it can include landscaping, it can include swimming pools, so it can be something outside the actual home itself. But it's anything that takes place within the home, or on the grounds of the home, would constitute a home improvement contract. Likewise, home improvement contractor is very broadly defined. In order to qualify as a home improvement contractor, all you have to do is jobs that total $1,500 or more in a year. That doesn't take much in this day and age to reach that threshold. And it covers any home improvement work in excess of $500, which is virtually everything nowadays. So if the contractor does work a total amount of more than $1,500, not on your house, but in total through all his or her jobs, and then your particular job is $500 or more, it's a home improvement contract and triggers the home improvement contractor law. Now, it doesn't apply to cosmetic things such as draperies or carpets. Those are not considered to be home improvement. It's kind of more structural types of things. However, if the carpets and draperies are part of a broader home improvement job, it would kind of fall within there. It doesn't include appliances, but in those instances, the appliances are generally covered by manufacturer's warranties anyway. But it would cover the construction, if it's more than $500, to put in those appliances. You know, you have to frame out something or do this or do that, and if it's more than $500, then it would fall within it. It also includes custom homes. So a new home that's built on land that's owned by the homeowner. It's not a home where the contractor builds a spec home. They own the land, they build the house, and then you come and buy the house and the land. It doesn't apply to that. But let's say you own land in Newfield and you want to put up a house. It would actually cover that particular circumstance. Though I sit back and think about it and say, how would anyone ever build a house without having a written contract? But it could potentially happen. But in this case, it must be in writing. The burden is upon the home improvement contractor to furnish the homeowner with the written contract. So it must be in writing. There are heavy penalties that we'll discuss a little bit later if they don't comply. But let's sit back and say, whether you're a homeowner or whether you're a contractor, it makes good sense to do everything in writing. More disputes arise because people don't get things in writing. We talk about it when we talk about leases here, where there's a miscommunication and it was all oral and one person thought one thing and the other person thought the other thing. Same with a home improvement contract. But it just makes good sense to put everything in writing so that you can just pull out the paper and say, well, you were supposed to do this, or I wasn't supposed to do that. Pull out the paper and it'll say right in it. So this law here, it really doesn't just protect the homeowner, although principally that's why it exists. But it really does protect both parties, and it makes sense for the contractor to have it in writing as well. It alleviates a lot of aggravation and problems that can arise. And that would also include, it makes sense, to any changes that you want to make to the plans or the specifications. Should also be in writing. It doesn't take much to just write down the change and whatever is going to be done and to have the homeowner sign it. Because frequently what will happen in those circumstances, they have the written contract, everything's going good, the homeowner wants something changed, the contractor says, yeah, I can do that. And then when it's done, it looks beautiful and everything's done. And the contractor goes back and asks for more money because there was extra expense. The homeowner would say, oh, wait a second, I thought it was just changed. We never agreed that it was going to cost another $1,000. That wasn't what our agreement was. And then, of course, the contractor's saying, what do you think? It's going to be extra work? I should get paid for it. Well, and then you have their dispute. Change order. Just put it in writing. And then the contractor can say it'll be an extra $1,000 right in the written contract. Homeowner signs it or initials it or whatever. Great. Then everybody knows. So if there's a dispute later, they can just pull out the piece of paper and say, hey, this is what the parties agreed to. So home improvement contracts must be in writing, and there are certain requirements that have to be in it. One is it has to have the name, address, and telephone number of the contractor. I see contracts all the time that don't have that. One of those things, maybe. Name, address, phone number of the contractor. Contract must include the dates of when the job is going to, the approximate dates of start and completion of the job. And part of that is that it should also list whether time is of the essence. Time of the essence is a legal term, which means that you got to really, those dates are set. You got to be start, you got to be done. Usually the contracts I see don't have that it's time of the essence, because people really, they understand things take time and there's going to be extensions and that sort of thing. But if it's important that it be done, your daughter's getting married and the reception's at the house and it's got to be done by a certain date, put time is of the essence. It's got to be done by that particular date. Then everybody knows. It has to have a description of the work, including the materials that are to be provided. Now, I don't think you really need every single board that's going to be put in there, but I think a good general explanation of what the materials are that are going to be included. If it is a particular type of bathroom installation, let's say, and that there's a specific type of sink and toilet and tub or shower that are going to be put in, you should put it in the contract so that, again, everybody knows what is being done here. Also, with the bigger type of home improvement contracts, if there's a draw schedule, the draw schedule should be detailed in the contract. What a draw schedule means is that the contractor is paid over a period of time as the project gets completed. So it might be, if they're doing an addition on the house, it might be that the first draw may be the deposit, or it may be that it's after the addition has been framed. Then maybe the next payment is when the addition has been sealed in and all the windows and doors and everything. And then it might be when the electric and plumbing are finished, and then there might be a final draw after the completion of the job. Whatever it happens to be, it should be detailed in there. Also, this is one of those very rare circumstances where you have 3 business days to cancel. The law specifically says with a home improvement contract that you have to be given a notice of right to cancel, and that you have 3 business days to cancel. The only exception to that here is in the case of an emergency. And the emergency has to be written out in the homeowner has to write it out and specifically write that they're waiving the 3 business days. It has to be an emergency. So you can see that circumstance where somebody's furnace goes, which would be a home improvement contract, somebody's furnace goes, they need a new furnace on January 2nd, especially this past winter that we had. You can't wait 3 days to get the new furnace in. So the homeowner could write on the contract, I need a new furnace and that otherwise I don't have any heat. This is emergency. I hereby waive the 3 business days to cancel this transaction. Because otherwise what would happen is if the contractor doesn't give the person their notice of right to cancel, or if the contractor begins work before the end of the 3 days, he or she runs the risk of having done all the work and then have the homeowner cancel the contract. Then they're really stuck and they'd have to go sue under a legal term called quantum merit, which is just value of goods and services delivered. But they wouldn't be able to sue under the contract because the contract has been rescinded by the consumer. So it's a huge hassle. So what typically would happen is that the homeowner would they'd sign the contract, and then the contractor would wait 3 days before starting to not going to do anything yet until we make sure that the time has passed, then they can't cancel. But I can't tell you the number of times that I see contracts that don't have a 3 business days to cancel. And not only did the work get done before the 3 days was up, but the homeowner was never furnished with their right to cancel. And if they aren't furnished with their right to cancel, the 3 days never starts to run. So they could wait till the whole job is over with and then say, oh, I cancel. And then the landlord's stuck and has to sue the homeowner for trying to get money for what work he or she has done. So it should be included with the contract, a notice of right to cancel, and that the owner needs to put in writing the nature of their emergency and why it's being waived. So that's the requirement of the home improvement contractor law, which is located in the general business law in New York. Another thing that frequently comes up with home improvement contracts is money. It's always about money, isn't it? It's always about the money. Any funds that are received by a home improvement contract for work to be performed later is by law labeled trust funds. And what does that mean? It means the money does not belong to the contractor. The contractor holds the money in trust for the benefit of the homeowner and can't use that money until he or she does the work or purchase materials for this particular job. And there's a fundamental reason why this law exists. Unfortunately, it still happens. But contractors will sometimes use people's deposits for the next job to finish paying for the materials and labor on the job that he or she's working on. Then when they get to the next job, they use other money to pay for it, and they build a house of cards that eventually will come crashing down. So the law is there to only use the homeowner's money for this homeowner's job. So it is trust funds, and it can't be used to put in the contractor's pocket or whatever. In essence, the contractor has to treat the money as if it's the money of someone else, because it is. It's to treat the money as if it's still held by the owner. It's not the contractor's money. Therefore, this is similar to the security deposits that we talk about with landlords, is that most questions you can answer by knowing that it's the homeowner's money. You can answer most questions anybody would ask as to how the funds should be used. For example, it cannot be commingled, put together with the contractor's other money, because it's not his or hers. It's not theirs for their use. So they can't put it with their other money. That needs to be kept separate. They would open a trust account at a bank or a financial institution and only withdraw it according to the draw schedule or according to material receipts that they get for or purchases. And again, it's that money is in trust, and it's for the protection of the owners, and it's also for the protection of someone else, and that is subcontractors. So subcontractors that haven't been paid, that's for the protection of. So any payments received prior to substantial completion must go into this escrow or trust account. It must be deposited within 5 days of being received, and it has to be in a New York bank. A New York bank or New York credit union financial institution in New York. The property, again, remains the property of the owner. And unless the contract specifically says the name of the bank, within 10 days of receiving the deposit, the contractor must notify the homeowner what bank the money was put into. On top of that, and this is very crucial to home improvement contractors, and that is they must keep a record of the funds they received in trust, deposits paid. The money does not have, the contractor doesn't have to create a separate account for every job that he or she is working on. He can keep one trust account and put all customers' trust funds in there. But he or she must keep a record of who put money in, and when he or she withdraws the money, whose portion of the pool did he or she take the money out of. If the contractor does not keep records of how those trust funds were handled, the law presumes that the money was mishandled. And it's a crime. So the contractor can be arrested and prosecuted for mishandling of trust funds. Very serious matter. So they should make sure that they keep records and only withdraw from that trust account the amounts up to the deposit for that particular job. I'll use an example. Lawyers have the same requirements, very stringent requirements on how they handle client funds. In fact, they don't generate a whole heck of a lot of money anymore, but back in the day when this law went into effect, and again, this is for lawyers, they were called IOLA accounts. It's interest on lawyer accounts. And we have to deposit the funds in an IOLA account, which is an interest-bearing account, and keep records of it. If our trust fund, IOLA account, was ever to become deficient, like bouncing a check or something, that clearly meant that you're using trust fund more than what you have, it will trigger our licensing review. It'll trigger it. So we can lose our license. Many lawyers have been suspended or disbarred for mishandling other people's money. The contractors need to take this just as seriously. Absent any records, it's presumed to have been mishandled and that they could be prosecuted for it. So they really need to keep records. And I do see, recently our office did it was in the fall, summer or fall of last year. We did a sweep where we sent out letters to contractors asking them to furnish us with copies of their contracts and information regarding any trust accounts or anything. And I would say that the rule was more in the breach than in the compliance. And we ended up actually having agreements entered into with all these contractors saying that they understand that this is what the law is and they are going to comply with it, and they had to pay a small monetary penalty to us for not complying with the law. And it wasn't done to generate all kinds of money or that sort of thing. It was really done to get the word out. So this is additional word that goes out, and I guess people will be forewarned that if it comes to law enforcement's attention that this law is not being followed, written contracts, properly handling of escrow accounts, they run the risk of getting civilly prosecuted, or if in the case of mishandled trust funds, criminally prosecuted. So people need to be warned and do it appropriately. The use of the escrow account, the funds can't be withdrawn in excess of the contract amount, because when you think about it, it makes sense. Because if you withdraw more than what the contract amount was, actually more than what the customer put in as the trust fund fees, you by logic are starting to use somebody else's money in that trust fund. So you can't use somebody else's money for anything other than their job. So you have to be very careful. And again, a failure to deposit the money is a crime. Failure to properly handle the funds is a crime. As far as violating the home improvement contractor law, which is you got to have a written contract, you got to give 3 business days to cancel stuff, there can be fines up to $2,500 per violated contract. They're just a technical violation of the contract. Nobody did anything wrong, they're just technically wrong. It can be $100 per violation. This is in addition to any restitution that might be due to the customer. And on top of that, our office can step in and get injunctions with costs and restitution. The statutory costs are $2,000, up to $2,000. And the civil penalties can be as much as, depending on what the circumstances are, can be as much as $5,000 per contract. So it can get really, really high, really, really fast. So it's better to keep that in mind. Home improvement contracts are a prime area for scam artists. unlike some areas in New York State, upstate New York, including the Ithaca area, Tompkins County area, there is not licensing of home improvement contractors. Now, there are some licensing for electrical and plumbing that you need to comply with, but that's not a kind of a general home improvement contractor licensing law, because there is not. In Long Island and New York City, it's done countywide, but in Long Island and New York City and a little bit above New York City, they actually have an infrastructure set up within the government to provide for the licensing of contractors. And I'll use New York City as an example. New York City has inspectors, that's all they do, that they inspect for people to be licensed and check jobs and that sort of thing to make sure it's complying with the plans and stuff. And there are heavy, heavy fines associated with it. I've heard circumstances, I was at a conference once in New York City, we were talking about home improvement contracting, and actually they say, we really don't have that big of a problem with home improvement contractors like we would upstate because of these severe penalties associated with licensing. There was one example, they were saying that if these inspectors are just driving around New York City and they see a van or a truck parked out front and has the magnetic sign on the side that says Tom's Home Improvement or something, they'll get right on the radio or the phone and call back to their licensing division and say, is this company licensed? And if they're not, they will tow that truck and impound it, and they have to pay fines, they have to get licensed, they have to pay fines and pay for the towing. So they'll just walk away. Also, I've heard in some Long Island instances, depending on what the law says for their particular county, if a home improvement contractor is not licensed, they are not entitled to be paid. So let's assume you hire somebody to put a deck on the back of your house. And it's a $10,000 deck. And the person is not a licensed contractor. And you say to that contractor after it's done, I'm not going to pay you. Well, that's not fair. The work is done. Let's say it was done great. The guy's not licensed. Done great, built perfect. He can't sue to get paid because he's not licensed. So there are really severe problems, in addition to the fact that they could be fined for doing work, but they might not get paid. So they don't have as big a problem. In upstate, we don't have licensing of contractors. There really isn't the infrastructure there to be able to have a whole governmental entity to be in charge and to inspect and do all that stuff and make sure contractors are licensed. And the fees that they have to pay downstate are pretty high, and might put contractors out of business if they had to pay here. But that leads to problems for us. We have many more problems here with home improvement contracting than they do downstate. It's a prime area for scam artists. Some tips for homeowners to protect themselves when undertaking or considering undertaking a home improvement contract. One is, don't pay unreasonable advance fees. In a lot of instances, small jobs especially, contractors don't ask to be paid until after it's done. Once somebody comes to you and they're doing a job that's only going to be a couple of days, and it's a $5,000 job, and they ask for the entire money up front, I would tell you red flags should be waving, sirens should be going off in your head. Usually contractors have a relationship with their supply houses, so they have a little bit of time to pay for the materials. And so they wouldn't even owe for the materials for your job until after it's completed in certain instances. There's nothing wrong with a deposit, especially if it's a big job or some work has to be done initially. But the way that you should focus on it as a homeowner is you should always be ahead. The contractor should not be ahead of you. So you should never, or unreasonably ahead of you as far as percentage of completion versus percentage of the contract that's paid. You should be kind of paying as you go along. If they ask for all the money up front, I would really be hesitant to getting involved in that. So don't pay unreasonable advance fees. Negotiate a schedule that would be based on completion at certain stages. Another great thing to be a good consumer is get estimates. The important thing for that is know exactly what you want done. Don't be talked into doing all kinds of extra things that you can't necessarily afford and don't want and don't need. Figure out what it is that you want to have or need to have done, and then go out and get estimates from reputable entities. On top of that, reputable, get references. Find out where the contractor has done work before and go look at it. Talk to the person. How was their experience in this contract? If the contractor's not willing to tell you where he or she did other jobs, maybe that's a red flag for you to decide that somebody else might be the appropriate person to do your job. Check and see if, in the case of where there is a license, like there might be a electrical license to the municipality, or plumbers have to get a license. Make sure they're licensed if there's a licensing requirement. See if they're insured. Make sure that they have insurance. And it would be liability insurance to protect in case they do something that hurts someone. And 2, make sure that they have workers' compensation insurance for their employees in case their employees get hurt. Get any guarantees that the contractor has for you in writing. I think it helps you that if you want something changed, get the change order so that it gets written down that this is what is going to be done. There's been talk throughout the years of getting statewide licensing and that sort of thing, but I've been doing this a long time, and there hasn't been anything to date. Know where your payments are going. Don't ever do business with a contractor who is unwilling to do any of these things ahead of time. Sign contracts or follow any type of law. Where's your deposit going? Ask them where the deposit's going to be held, and make sure that it gets handled appropriately. If you do this, you will go a long way toward protecting yourself and have a good experience with your home improvement contract. If you ever have a problem related to home improvement contractors, we in the Attorney General's office can't represent you, but we do have a mediation program available where anyone who has a complaint against a business, could be a home improvement contractor or some other business, they can file a complaint, a written complaint with our office. The complaint forms are available online at www.ag.ny.gov. You just go to that main page and you put in the search box consumer complaint form. And there's actually a page that has a list of all links to all the complaint forms for our office. Each regional office has its own address at the top. The complaint form is the same, but the address is different at the top. You can look for those of you in the Tompkins County area, you can look for the Binghamton Regional Office complaint form, and you just print it off, fill it out, mail it into the address indicated, and what we do is mediation. We take your complaint and we send it to the business, and we say, we've only heard one side of the story. We'd like to hear your side of the story. Please respond to us. Respond to the complaint that we've enclosed. And it's usually pretty effective in getting a response. Sometimes it's not the response that the consumer wants to hear, but that's the nature of mediation. We try to resolve it. If we're unable to resolve those sorts of things, the consumer always has the opportunity to speak to their private attorney about possibly bringing a case against the contractor for what they didn't do or didn't do right. Regardless, I would still encourage you to file a complaint with our office, because our office keeps a record of every complaint that we receive, so that we may have a situation where we only have your particular complaint, and we really don't have jurisdiction to do anything at that point because we can't represent individuals. We couldn't represent you in your case. But Your complaint may also be in addition to a few other complaints that we have against the same contractor for doing the same thing. That might furnish the basis for the Attorney General's office to have jurisdiction. And we could sue the contractor for illegal, deceptive, and fraudulent business practices for repeatedly and persistently violating the law. So we use that as a way to see what's going on out there. So we can get your complaints in. So we encourage you to file those complaints. Otherwise, if anyone has any questions regarding home improvement contracts, I'd be glad to answer them. And if not, I thank you. I hope people will come and join us next time when we come out here. And I'll hand it back to Carol.
Thanks so much, Mike, for sharing all this great information on helping us be wise consumers in the home improvement marketplace. If you have a repair person or a contractor come to your home, you may be given information about lead-based paint hazards if your home was built before 1978. Since 2010, we've had a law on the books, a federal law, that says that contractors that perform renovation, repairs, or painting on homes that were built before that time that disturb lead-based paint, they must be certified and must follow specific work practices regarding lead paint and to prevent lead contamination. So be aware of that. Contractors, homeowners, or tenants who would like more information about this can contact our office here at Cooperative Extension. Another aspect of indoor air quality in this area is radon gas. Homes in this area are likely to have elevated levels of radon, which is a health hazard, and should be tested. So please contact our office, our consumer helpline again, if you'd like more information on radon, what it is, how you can test your home for it, and what to do if you have elevated levels of radon. We'd be happy to share that information with you. You can also contact our consumer helpline if you'd like more information about this topic of home improvements or any other consumer topic. We have staff and volunteers who are trained and will help to provide you with answers that are research-based, unbiased information, and to help you explore your options regarding any of these consumer issues. So please call our consumer helpline at 272-2292 during weekdays. Thank you for joining us today. If you're watching this program on cable channel 15, we would like you to know that if you'd like to share this program, that it will be rebroadcast every Monday during the month of May at 7 a.m., 1 p.m., and 7 p.m. So if you'd like to watch it again, or if you'd like to let somebody else know about it, please know that it will be broadcast at those times. If you'd like to join us live next time, we'd love to have you here down at Cooperative Extension. We're located at 615 Willow Avenue in Ithaca, and we are live and held on the second Thursday of each month at 11 a.m. These programs are free and open to the public. Just come on down if you can make it. Next month, our topic will be exploring tenant-landlord rights and responsibilities, and we hope you'll join us. Thank you.